Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
The question of how often trademarks should be monitored is not a matter of ticking a box on an operational checklist. It goes much deeper. It is a central part of any serious intellectual property strategy, and it is critical for maintaining brand integrity and competitive advantage in a global marketplace. Registering a trademark is only the beginning. Protecting it requires continuous, systematic vigilance. Why is that so important? Because proactive monitoring allows you to detect problems before they escalate. If an infringing application appears in an official register, or if someone uses your brand name or logo online without authorization, catching it early gives you the power to act. Sending a cease and desist letter or filing an opposition during the short opposition window is far more effective and affordable than entering litigation once the infringing brand has already taken hold. Delay can be fatal, not only financially, but legally. In some jurisdictions, such as the United States or the United Kingdom, courts may even deny enforcement if you have neglected to police your mark. There is also the matter of distinctiveness. A trademark only remains strong if it remains unique. If similar or confusingly close marks are allowed to circulate, your brand begins to lose its identity. Customers get confused, trust erodes, and the very equity of your brand diminishes. Regular monitoring ensures that you stay in control of how your brand is perceived and that its distinctiveness is never watered down. Another dimension is compliance with legal frameworks. Trademark rights are not self-executing. In many systems, owners must demonstrate active use or submit declarations to keep their registrations alive. Monitoring the marketplace and trademark registers allows you to prepare for these obligations, to defend against cancellation actions, and to prove that your mark is being properly enforced. And then there is the strategic advantage. Monitoring is not only about defense, it also gives you valuable insight into what your competitors are doing. Watching new filings and online activity can reveal market shifts, expansion plans, or emerging trends. This knowledge can inform your own strategic planning, guide innovation, and even highlight new opportunities for growth. How frequently should this monitoring happen? The answer depends on the channel. Trademark registers are the primary battleground, and they must be checked regularly. Opposition periods are short, often only 2 or 3 months in Europe, so a monthly or ideally weekly review of these databases is recommended. National offices such as the USPTO in the United States, the EUIPO in Europe, and the DPMA in Germany all publish new applications continuously. Tools like WIPO's Madrid Monitor make it possible to see filings in real time, but vigilance is key. In the digital world, the pace is even faster. Domain names are registered around the clock, and cyber squatters do not wait. E-commerce platforms such as Amazon or Alibaba, and social media spaces like Instagram, TikTok, or LinkedIn are dynamic environments where misuse can appear and disappear within hours. Here, continuous and often automated monitoring is indispensable. Search engines and digital advertising also require constant attention, as competitors may use your trademarks as keywords to divert traffic or confuse potential customers. Finally, businesses need to step back and look at the bigger picture. At least once a year, and ideally once per quarter, it is essential to conduct a strategic review of the entire trademark portfolio. This ensures that monitoring efforts are aligned with business objectives, that new risks are identified, and that your strategy adapts to changes in the market and in the law. Of course, the scale of this task is overwhelming if done manually. That is why artificial intelligence has become such a powerful ally. AI systems now scan vast amounts of digital content in real time across marketplaces, ad networks, and social media platforms. They recognize logos and packaging through image recognition, analyze text across multiple languages with natural language processing, and even detect patterns that may predict future misuse. In emerging areas such as NFT marketplaces or other decentralized platforms, AI tools are already being developed to spot unauthorized use of brand assets. They can even automate parts of the enforcement process, such as sending takedown requests. Yet technology alone cannot do the job. human expertise remains indispensable. Legal professionals bring the ability to interpret findings, to weigh risks, and to make strategic decisions about when to negotiate, when to send a warning, and when to go to court. The most effective strategy is therefore hybrid. The speed and scale of AI combined with the judgment and strategic acumen of experienced trademark lawyers. In the end, the lesson is simple. Monitoring your trademarks is not a task you schedule once in a while. It is a living, breathing part of brand management. By combining real-time, technology-driven monitoring with expert legal oversight, companies can not only safeguard their marks but also make smarter strategic decisions, protect their market position, and secure a competitive edge in an increasingly complex and interconnected economy.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.